5 seconds to go. Start. The appellant has not furthered any evidence to indicate that prior approval was taken, and this has been noted by the High Court. The appellant is stopped from denying the applicability of the DACP scheme to the contesting respondents since they made such a representation in their recruitment advertisements. The contesting respondents have acted on such representations to quit their existing jobs. Even if the ESIC recruitment regulations 2015 were held to be validly issued, the contesting respondents had already completed 2 years of service before they came into effect on 5th July 2015. Therefore, the contesting respondents should be considered for promotion in accordance with the DACP scheme in view of the decisions of this court. All the contesting respondents had 3 or more years of teaching experience before they joined the appellant as assistant professors. The qualifying service of 5 years under the ESIC Recruitment Regulations 2015 should be given a reasonable interpretation, and the cumulative experience of more than 5 years should be held sufficient for promotion. The doctors and medical teaching staff in the central government are being promoted in accordance with the DACP scheme. The arbitrary denial of the DACP scheme to the contesting respondents' teaching cadre of the appellant violates Article 14, especially when they are also discharging functions of attending to patients and performing specialized clinical work, and in other legal proceedings the appellant has taken the stance that the DACP scheme is applicable to its employee with effect from 1st March 2008 itself. The rival submissions will now be analyzed. The crux of the dispute is about determining the applicable rules regulations for promotion of the contesting respondents from the post of assistant professor to associate professor, namely the ESIC Recruitment Regulations 2008, the DACP scheme, or the ESIC Recruitment Regulations 2015. On 29th October 2008, the 6th Central Pay Commission recommended the extension of the DACP scheme to all doctors in employment of the central government. The recommendations were accepted by the Union Ministry of Health and Family Welfare through an office memorandum dated 29th October 2008, which extended the DACP scheme to medical and dental doctors in the central government. In continuation of the office memorandum, the Government of India issued another office memorandum dated 29th October 2008 detailing promotion under DACP in various cadres under the Ministry of Health and Welfare. The scheme enabled promotion from the post of assistant professor to associate professor after 2 years of service. The controversy in the present appeal arises out of the interpretation of section 17(2)(a) of the ESIC Act 1948 and the applicability of the Office Memorandum dated 29th October 2008 against the ESIC Recruitment Regulations 2008 and the subsequently issued ESIC Recruitment Regulations 2015. Section 17 of the ESI Act 1948 provides as follows. Stop.